So, as you all know, Donald Trump signed an executive order on his first day back in office that would effectively end birthright citizenship, which is not something that he can do since it's codified in the 14th Amendment to the U.S. Constitution. And several district courts have said that this executive order is obviously unconstitutional. For example, U.S. District Court Judge John Coffenauer called it blatantly unconstitutional, and he was one of many judges to issue an injunction which blocks Trump's executive order from taking effect. And when the Trump administration tried to pause Judge Coffenauer's injunction, a federal appeals court then slapped them down once again, because obviously a court can say, no, you're not allowed to draft an executive order that overrides the Constitution. So court after court after court has made it very clear that Trump's executive order cannot override the 14th Amendment. And if he wants to do away with birthright citizenship, he technically can do that, but he needs to propose a constitutional amendment, which would then need to pass both the House and Senate by a 2/3 majority, and then that amendment would need to be ratified by 3/4 of the states. You don't get to just rewrite the Constitution with the stroke of your pen. And the courts have reiterated this multiple times now. But of course, the Trump administration isn't content with this outcome. So they've taken this case to the Supreme Court in hopes that they will let them bypass the lower court injunctions preventing him from violating the Constitution. And ahead of oral arguments, Trump tweeted about why he wants to end birthright citizenship via Truth Social, arguing birthright citizenship was not meant for people taking vacations to become permanent citizens of the United States of America and bringing their families with them, all the time laughing at the suckers that we are. The United States of America is the only country in the world that does this. For what reason, nobody knows. But the drug cartels love it. We are, for the sake of being politically correct, a stupid country, but in actuality, this is the exact opposite of being politically correct, and it is yet another point that leads to the dysfunction of America. Now, as you can see, he goes on, but it doesn't matter because you still don't get to override the Constitution with a fucking executive order. So if you don't like it, tough shit. So this, in theory, should be another obvious 9-0 Supreme Court decision against Trump, right? Well, here's the thing. Trump's lawyers aren't actually asking the Supreme Court to weigh in on the constitutionality of that executive order. Instead, they're asking the Supreme Court to stop lower courts from stopping him from violating the Constitution. As SCOTUS blog explains, though the dispute comes to the justices through challenges to Trump's effort to end birthright citizenship, the primary issue before the court on Thursday is whether lower court judges can issue what are known as universal injunctions to block an order nationwide. With a universal injunction, a federal judge, or several in this case, can bar the government from enforcing an executive order, or in another case, a law or policy, anywhere in the country. The Trump administration, which has been blocked by many such injunctions in recent months, argues that the practice is unconstitutional. And that's the question before the Supreme Court. But I mean, think about how absurd this is. The Trump administration is basically arguing that it's unconstitutional for lower courts to stop him from violating the Constitution. No, they are protecting the Constitution from him. But rather than asking the Supreme Court to rule on the substantive question here, which is whether or not Trump can override the 14th Amendment via an executive order, Trump's attorneys are instead trying to narrow the scope of their case to get the Supreme Court to make a decision only on procedural grounds vis-a-vis injunctions. And Trump's lawyers are specifically asking the Supreme Court to stop district courts from issuing nationwide injunctions because they don't want to talk about what these lower courts are blocking. And during oral arguments, Justice Kagan pointed out the absurdity of the argument they're making.
I mean, let's assume that you lose in the lower courts pretty uniformly, as you have been losing on this issue, and that you never take this question to us. I mean, I noticed that you didn't take the substantive question to us. You only took the nationwide injunction question to us. I mean, why would you take the substantive question to us? You're losing a bunch of cases, this guy over here, this woman over here, they'll have to be treated as citizens, but nobody else will. Why would you ever take this case to us?
Well, in this particular case, we have deliberately not presented the merits to this court on the question of the scope of remedies, because, of course, that makes it a clean vehicle where the court doesn't have to look at the past.
You're ignoring the import of my question. I'm suggesting that in a case in which the government is losing constantly, there's nobody else who's going to appeal, they're winning, it's up to you to decide whether to take this case to us. If I were in your shoes, there is no way I'd approach the Supreme Court with this case. So you just keep on losing in the lower courts, And what's supposed to happen to prevent that?
Again, I respectfully disagree with that forecast of the merits, but in response to the question, what I would say is we have an adversarial system, and if the government is not, for example, not respecting circuit precedent on the court's hypothetical in the Second Circuit, someone injured in the Second Circuit could take the case up, and they could say, look, the government is violating circuit precedent on the hypothetical multiple circuits.
That's the case we're going to take? Somebody who says, you know, after we've said that this all has to be done one by one by one, then we're going to take a case from somebody who objects to proceeding one by one by one?
So, legal jargon aside, Justice Kagan is basically saying, we know why you don't want us to address the substantive question here, because you'd lose, and you know it. But if the Trump administration can sidestep the main substantive question and simply get the lower courts off of their backs, they'd be able to, at least temporarily, do what they want, which is violate the Constitution. But that doesn't change the fact that the executive order itself is obviously unconstitutional. So if the lower courts can't offer a remedy in the form of sweeping injunctions and Trump is allowed to violate the Constitution, the next question is, how do we get to the correct outcome here, where the 14th Amendment isn't being violated by a rogue administration? Because if courts can't issue universal injunctions, Trump's obviously going to break the law. And Justice Kagan asks this question to Trump's attorney, and as you're going to see, she wasn't very impressed with his answer, and she wasn't the only one.
How else are we going to get to the right result here, which is on my assumption that the EO is illegal?
That would be a profoundly wrong result, but I think what I would offer is that, very similar to Labrador against Poe, what the court should be engaging here is a balancing of the equitable factors as to the scope of remedial relief, not as to the underlying merits. And our contention that this exceeds the traditional scope of equity that's reflected in the 1789 Judiciary Act, we're overwhelmingly likely to succeed on those merits for all the reasons that are stated in our briefs.
I mean, that's a lot of words, and I don't have an answer for if one thinks. And, you know, look, there are all kinds of abuses of nationwide injunctions. But I think that the question that this case presents is that if one thinks that it's quite clear that the EO is illegal, how does one get to that result, in what time frame, on your set of rules, without the possibility of a nationwide injunction?
On this case and on many similar cases, the appropriate way to do it is for there to be multiple lower courts considering it, the appropriate percolation that flows to the lower courts, and then ultimately this court decides the merits in a nationwide binding precedent. You have a complete inversion of that through the nationwide injunctions with the district
So, General
courts.
Sauer, are you really going to answer Justice Kagan by saying there's no way to do this expeditiously?
Well, I'll refer to my former answers. Rule 23 provides the tools to do so, multiple injunctions.
But you resisted Justice Kagan when she said, could the individual plaintiffs form a class?
That has never been briefed in the court below. I do not concede that we wouldn't oppose class certification in this particular case. There may be arguments that this case is or is not appropriate for class certification. And
if there were a class appropriate for class certification, you concede that that could resolve the question quickly?
Yes, absolutely.
You concede it could resolve the question quickly through precedent?
Yes, absolutely.
So assuming the Supreme Court were to agree with Trump's attorneys here, and they no longer allow district court judges to issue universal injunctions, then what do people do? And Trump's attorney can't say. He cannot say how individuals being harmed by this rogue administration would be able to find a remedy, because the nationwide injunction is the remedy. And that's the point. That's why they want to take it away. So the question is, what are these people supposed to do if Trump chooses to violate their rights? And the answer, I guess, is each individual person has to sue. For example, if Trump signs an executive order banning gay marriages and a lower court blocks that order and issues a nationwide injunction, it would protect every single couple affected by this, since they'd constitute a class of people whose rights were violated by that order. But if they couldn't issue an injunction and the Supreme Court agreed that, district court judges can't do this, then the only way that couples affected by that order would be able to get relief would be to sue the Trump administration themselves, one by one, literally. And I think that Justice Ketanji Brown Jackson put it best, saying, your argument seems to turn our justice system, in my view at least, into a catch-me-if-you-can kind of regime from the standpoint of the executive, where everybody has to have a lawyer and file a lawsuit in order for the government to stop violating people's rights, Jackson said. I don't understand how that is remotely consistent with the rule of law. And as Sotomayor put it, allowing the government to deny citizenship to U.S.-born children of non-citizens while they seek individual relief from an unconstitutional act by the president is similar to requiring every individual gun owner to sue on their own if a president ordered the military to take all guns from U.S. citizens, Sotomayor argued. And they're exactly right, it'd be unworkable. So that's why Barrett was asking him about classes, because they're basically trying to violate the Constitution and leave people with almost no options to stop them from taking away their rights. I mean, if 3 million people had their rights violated because of some executive order that Donald Trump signed, it is unreasonable to expect all 3 million people to literally sue the federal government. I mean, they're not going to have the means or the time to do that, not to mention the entire court system would be bogged down by 1 million new cases, or 3 million new cases in this particular analogy. Trump's attorneys know this, and they're trying to create a situation where they're able to violate the Constitution, people's civil liberties, civil rights with impunity. That's what this is about, and this is exactly what would happen if judges couldn't issue universal injunctions. And in case you missed it at the beginning, Trump's attorney literally said that it was profoundly wrong to rule that Trump's executive order is illegal. Did you catch that? So he's arguing, the U.S. Solicitor General is arguing that he effectively thinks that Trump is more powerful than the U.S. Constitution, because it's not a question as to whether or not that executive order is unconstitutional. It is, but he's saying it's not. So you think that Trump is above the law and the Constitution. That is the actual argument that he's making in court. It is fucking insane. He's making this argument, by the way, under oath with a straight face. Now, we know even he does not believe that fucking bullshit. And we know that because if he did actually believe that, then he would have asked the Supreme Court to rule based on the substance of Trump's executive order and not on procedural grounds. But since he's trying to score a win simply on procedural grounds, that is evidence that even they know that they're wrong. But on top of that, I don't know why they're even concerned about nationwide injunctions, given how this administration has been ignoring courts. So why do they even care? Like, let's say the Supreme Court rules against them in this case, and nationwide injunctions are allowed to stand. There's a legitimate question as to whether or not they'd respect those injunctions, even if they lose. And we know this because Trump's lawyers shamelessly would not commit to respecting decisions of lower courts, and they said this to the Supreme Court.
You're not willing to commit to abiding by the Second Circuit's precedent in my... Suppose that there's a single person who brings a suit, and it gets all the way up to us after 3 or 4 or 5 years. And we say, you know, we really do agree with those 4 precedents that Justice Sotomayor started with, and your EO is illegal. Is that only going to bind the one guy who brought this suit?
No, that would be a nationwide precedent that the government would respect.
So finally, once it gets to us after 4 years, you're going to respect that?
Yes, and in addition, we may well respect circuit-wide precedent. The Second Circuit, it just is...
And for 4 years, there are going to be like an untold number of people who, according to all the law that this court has ever made, ought to be citizens who are not being treated as such.
Amazing. So they won't commit to abide by lower court rulings, but in the event it reaches the Supreme Court, only then would they comply. Now, I, for one, have a hard time believing that, given how they're currently refusing to comply with a 9-0 Supreme Court decision, which orders them to facilitate the return of Abrigo Garcia. And even if they did respect the Supreme Court, as Justice Kagan pointed out, there's going to be countless people harmed by this abuse of power in the meantime, by the time this case works its way through the system all the way up to the Supreme Court. And the fact that this administration won't commit to respecting lower court decisions, and they're saying this, again, to the Supreme Court, is absurd in and of itself. But thankfully, that absurdity wasn't lost on Justice Barrett, who pressed him on that.
Did I understand you correctly to tell Justice Kagan that the government wanted to reserve its right to maybe not follow a Second Circuit precedent, say, in New York, because you might disagree with the opinion?
Our general practice is to respect those precedents. But there are circumstances when it is not a categorical practice. It is, and that is not
this
a new
administration's
policy.
practice or the longstanding practice of the federal government? And I'm not talking about in the Fourth Circuit, are you going to respect a Second Circuit? I'm talking about within the Second Circuit. And can you say, is that this administration's practice or a longstanding one?
As I understand it, longstanding
Really?
policy of the Department of Justice. Yes, that we generally, as it was phrased to me, generally respect circuit precedent, but not necessarily in every case. And some examples might be a situation where we're litigating to try and get that circuit precedent overruled and so forth.
Well, okay, so I'm not talking about a situation in which, the Second Circuit has a case from 1955 and you think it's time for it to be challenged. That's not what I'm talking about. I'm talking about in this kind of situation. I'm talking about this week, the Second Circuit holds that the executive order is unconstitutional, and then what do you do the next day or the next week?
Generally, we follow those.
So you're still saying generally?
Yes.
And you still think that it's generally the policy, longstanding policy of the federal government to take that approach?
That is my understanding.
Okay, so, but it sounds to me like you accept a Cooper versus Aaron kind of situation for the Supreme Court, but not for, say, the Second Circuit. Like where you would respect the opinions and the judgments of the Supreme Court, and you're saying you would respect the judgment, but not necessarily the opinion of a lower court.
And again, I think in the vast majority of instances, our practice has been to respect the opinion as well, in the circuits as well, but my understanding is that has not been a categorical practice in the way respect for the precedents and the judgments of the Supreme Court has been.
So you're not hedging at all with respect to the precedent of this court?
That is correct. I believe the quotation from our application directly addresses that, and we stand by that completely.
Okay.
It is genuinely insane to hear the United States Solicitor General say that they generally abide by rulings. What do you mean you generally abide by rulings? That implies that you don't abide by all rulings. So what, you're just picking and choosing rulings that you don't like? I mean, we know that this is the case because that's what they're doing, but you're admitting this in court. I mean, if you don't like a decision, you appeal it. You don't get to choose which rulings to abide by. At least that's how it used to be. But, I mean, it seems like we won't get to see whether or not this administration respects lower court injunctions because based on analyses by numerous publications about these oral arguments, the consensus seems to think that the Supreme Court is actually poised, believe it or not, to side with Trump here. I wish I was making this up, but they're buying the bullshit procedural argument that Trump's attorneys are making. HuffPost explains at least 5 conservative Supreme Court justices appeared supportive of arguments in favor of limiting how federal district courts can issue universal nationwide injunctions on executive branch policies, which would allow President Donald Trump's executive order limiting birthright citizenship to at least temporarily go into effect. This is insane. Such a decision could create a patchwork of citizenship throughout the country for the first time since the end of the Civil War and make it far more difficult for the children of non-citizens to bring suit to obtain the citizenship owed to them by birth under the Constitution. In other words, the U.S. Supreme Court is effectively letting the president override the U.S. Constitution. That is what is happening here. This is insane. If they actually do rule in his favor, they are stopping district courts from reining in his abuse of power and basically arguing that the courts are the ones overstepping by stopping the president from overriding the Constitution with a fucking executive order. So, since they're presumably taking away one of the main checks on Trump's tyranny, that basically means anything goes. Goodbye due process, goodbye habeas corpus, goodbye First Amendment, because if they take away one of the main tools that federal judges use to stop him from violating the Constitution, then he's going to be able to violate the Constitution. And they know this is what it's going to lead to, which is why they were very happy to only address the narrow parameters laid out by Trump's attorney. For example, Politico adds, quote, "Let's put out of our minds the merits of this and just look at the abstract question of universal injunctions," Justice Samuel Alito said. "The practical problem is that there are 680 district court judges, and all Article 3 judges are vulnerable to an occupational disease, which is the disease of thinking that I am right and I can do whatever I want." That's incredibly ironic, seeing as how the courts are the ones stopping Trump from doing whatever he wants. What are you saying? There's no way that Alito even believes the bullshit that he's spewing. It's completely disingenuous and cynical. But I guess if we ever get a Democratic president, they can technically sign an executive order banning guns in defiance of the Second Amendment, and courts don't get to stop them. So that's what happens when all bets are off. That's what happens when the Constitution is no longer in effect and we're just governed by decree. But I mean, with regard to birthright citizenship in particular, assuming Trump is going to take that away, seems like he's going to be able to do that, at least temporarily. There's an entirely different question that the Trump administration apparently hasn't even considered, which is how they'd even enforce something like this. And even Trump's attorney doesn't seem to know how they're going to enforce something like this, because how would you know that? It seems impossible.
On the day after it goes into effect, this is just a very practical question how this is going to work. What do hospitals do with a newborn? What do states do with a newborn?
I don't think they do anything different. What the executive order says in Section 2 is that federal officials do not accept documents that have the wrong designation of citizenship from people who are subject to the executive order.
How are they going to know that?
The states can continue to, the federal officials will have to figure that out, essentially.
How?
So you could imagine a number of ways that the federal officials could.
Such as
they could require a showing of, documentation showing legal presence in the country. For a temporary visitor, for example, they could see whether they're on a B-1 visa, which would exclude kind of the birthright citizenship in that country.
For all the newborns? Is that how that's going to work?
Again, we don't know.
Incredible. The only thing that might actually be our saving grace is their incompetence and just straight up stupidity. And I love how a Supreme Court justice is even entertaining the prospect of a blatantly unconstitutional executive order going into effect. You are there to stop things like this from happening. So why are you letting this happen? Wild times. I can't believe my fucking ears. So listen. We are officially in uncharted territory, because if the Supreme Court is effectively permitting the president to violate the Constitution by siding with them on procedural grounds, the president is all powerful. Nothing is off the table. So assuming we don't transition from a soft dictatorship to an actual dictatorship in the future, the next Democratic president better take note. Because if the Constitution doesn't matter, then let's capitalize on the collapse of the rule of law. Let's get a Medicare for All executive order on day one. Cancel all of our student debt and our medical debt with the stroke of a pen, and do a bunch of good things with your pen. Because, if Trump can override the Constitution and straight up just ignore courts to do bad things, then I think that a Democratic president should override the Constitution and ignore courts to do good things. I don't feel comfortable about this. This is not a new normal that I wanted, but this is the country conservatives have created for all of us. And what's good for the goose is good for the gander. So get ready, Democrats, because when you take back power, you now have unlimited power to do whatever the fuck you want, thanks to Donald Trump and the Supreme Court.
I'm gonna come.
Do not come. Come.
Welcome to the Come Zone.